Thanks for stopping by and checking out my videos. And if you want to learn more about my book, Love Like Snow in Florida on a Hot Summer's Day, go down to the description. I have the links to both my website and Amazon and Kindle Unlimited, where you can read it for free. Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And if you checked out my last video, it was the government's response to the defense's opposition to their motion in limine, which is where they were trying to ask the judge for permission to add these, I believe it was 13 additional Jane Does and 2 John Does. And these are people who have allegations against R. Kelly, but they haven't had criminal charges filed. They're not a part of the indictment. And so after I finished that video, or I was saving the video, and I went back to check something, and I realized that there was a second response that was filed by the government. And so I am going to do this one. Thank God it's not as long as the one that I just did, which was about 30 minutes, but they're still dealing with the defense's opposition to this additional evidence, these additional alleged witnesses, victims, however you want to put it. And so we'll go ahead and I will read this to you guys. And so it says, United States, versus Robert Sylvester Kelly. Dear Judge Donnelly, the government writes in reply to the defendant's response in opposition to the government's motion in limine to admit other acts evidence. And I think in the last one I said that was the bad acts, but that was actually evidence that they were trying to put in. Now I guess they're going to talk about the bad acts witnesses. And so it says that the government's motion in limine to admit certain uncharged acts dated July 13, 2021, docket entry number 146, defense motion or memorandum for the reasons set forth herein and in the government's initial memorandum, the government's motion should be granted. First, all of the other acts evidence the government seeks to offer is admissible as direct evidence of the charged racketeering offense, a fact the defendant fails to mention in his response, and therefore the notice provisions of Rule 404B of the Federal Rules of Evidence do not apply. See example, government motion to admit certain uncharged acts at 31. And I think they may be referring to page 31 because this was one of those, either the 55 or the 61 page motion that I read to you guys last week. And so in its initial memorandum, the government cited Rule 404B only as an alternate basis for admission of this evidence. Significantly, as set forth in the government's memorandum in support of this motion to admit certain other acts evidence, a racketeering offense is not limited to just the enumerated racketeering acts. Rather, it is the combination of both the activity of the enterprise and evidence of the pattern of racketeering, demonstrating that the defendant's conduct is interrelated and that there is continuity of a thread of continuity, often through the presentation of uncharged other acts. And then it gives a case that they want the government or the judge to go and look at, and it says, as clearly set forth in the government's memorandum, the other acts evidence discussed therein falls squarely within the time frame of the charged racketeering activity of, in, or about January 1994 and the present. And then it says, and involves not only the defendant's own conduct, but his use of and reliance on various members of the charged enterprise to carry out the uncharged acts as part of the methods and means of the pattern of racketeering charged in this case, including but not limited to selecting victims, alleged victims, making travel arrangements, and carrying out the defendant's instructions, which were used to control and silence his alleged victims. The proffered evidence thereof reflects not only the defendant's pattern of racketeering, but also the long-standing continuity of such conduct committed by the defendant and other members of the enterprise throughout the duration of the racketeering period. First of all, you have not established an enterprise. Let's start with that. And then number two, you're trying to enter Demetrius Smith, who I'm assuming that you have granted immunity to, but you never charged him with any crime. So I'm not sure how you're making him part of the enterprise of which he was never indicted or charged with being a part of. You basically told him, come in here and tell us your story, and we promise not to charge you in the long run, okay? So anyway, you guys can tell I'm kind of getting bored with this, right? So second, even if the notice provisions of Rule 404B did apply, the government has complied with those provisions. The court set the schedule to file motions in limine on February 9, 2021, and at no time did defense counsel seek an earlier date for the filing of the government's Rule 404B motion. Well, first of all, we have totally different attorneys, okay? So you can't blame the Devereux Connick man and the new attorney with what Steve Greenberg did not do. And then it says, see minute entry dated February 9, 2021. The government was prepared to file its motions on Monday, July 19, 2021, but the defendant sought an extra 4 days for the filing of motions in limine, an extension to which the government did not object. So then we decided we was going to delay for 4 days also, okay? So see letter of Thomas Farinella to the court dated July 19, 2021. Docket number 131. Regardless, the government's notice was sufficient such that the defendant has a fair opportunity to meet it. See Federal Rules of Evidence 404B3A. Significantly, the government has had ample notice of the government. Significantly, the defendant has had ample notice of the government's evidence, as the substance of these uncharged acts and the evidence supporting them were disclosed in the government's production of 3500 material, as well as in prior production of Rule 16 discovery. This is also true of the allegations concerning John Doe number 1 and John Doe number 2. The government disclosed 3,500 material relating to both John Does on February 5, 2021, as well as discovery material corroborating their claims. Thus, the defense had ample notice of the allegation of the activity between the defendant and John Doe number 1 and John Doe number 2, and could have sought to include a question regarding such allegations in the questionnaire. Moreover, jury selection is not complete, and should the defendant request, the court could pose additional relevant question as to this topic to the veneer during the jury selection process. And then once again, Devereux Cannick was not part of the team back in February. He only recently joined the team, so it's kind of tacky that you're trying to say that he had ample time to submit these questions, unless you are referring that to Nicole Becker and to Thomas Farinella, who did not file that motion to you. Somebody else filed that motion to you. But in any event, and then also they were not the lead counsels, and we don't know if they saw all of the discovery that was given to Steve Greenberg, because I believe Thomas Farinella stated in a previous document that they did not have access, that Greenberg did not distribute the discovery or the 3500 material to the other members of the team, and nor had Mr. Kelly seen any of this discovery or 3500 materials that you are referencing here. And so the reason Greenberg and Leonard are no longer on the case is this is one of the reasons, is because they were not divulging information to the other counsel. So it goes on to say, nor is there any merit to the defendant's allegations that there is no evidence supporting activity between the defendant and Jane Doe number 1 while she was underage. There is absolutely no physical proof nor circumstantial proof that any of these allegations put forth by the government are true. Jane Doe number 1 is unable to testify that any of the above allegations are true. They are merely accusations that assist in forming the government's narrative. And that's what Devereux Cannick wrote in his response in his opposition. So a witness number 1, who is Demetrius Smith, drug addict who stole from R. Kelly and all that stuff, who has every reason to be lying at this point, is unable, will testify that the defendant admitted to him that based on information the defendant obtained from Jane Doe number 1, the defendant believed Jane Doe number 1 was pregnant by him. In addition, Demetrius Smith will testify that based on the defendant's statement and demeanor, he believed that the defendant was the individual who impregnated Jane Doe number 1, including because the defendant admitted that he, the defendant, was advised that he would need to marry Jane Doe number 1 to escape prosecution. Many of these admissions were made just before Demetrius Smith helped the defendant arrange an unplanned flight to return to Chicago while the defendant was on tour in another state to secretly marry Jane Doe number 1. In addition, another witness, Jane Doe number 7, will testify that she saw the defendant, and this is the Cunningham girl, Javante, I think, or Javanta, something like that. Cunningham will testify that she saw the defendant engaged in contact with Jane Doe number 1 in or about 1992 when Jane Doe number 1 was 13. These people are so stupid. Jane Doe number 5, who we know is Azrael, crazy ass, also will testify that the defendant admitted to her that he married Jane Doe number 1 when she was 15 because she was pregnant, and he wanted to be protected by law if they were married. He apparently believed that spousal privilege would preclude Jane Doe number 1 from testifying against him. The evidence is also barred by Rule 403, as the defendant argues. The evidence is not barred by Rule 403, as the defendant argues. Okay, now first of all, can we just say this? So basically, they want to enter in hearsay evidence because there is no proof that this conversation took place between him and Demetrius Smith. And we know good and doggone well that he did not have this conversation with Azrael, who has proven time and time again that she is a pathological liar and will make up stuff as she goes. And if Judge Dunley allows this nonsense in, then shame on her, because I don't know any court that would just allow people to come in and say, somebody told me that. Because rule number 1 in Judge Judy's court is she will cut people off quick, fast, and in a hurry when they start saying what somebody told them. And she will say, you cannot tell me what another person said if that person is not here for me to ask them if they said that. So this is crazy. But anyway, so then they have in the notes, Jane Doe number 2 will potentially be part of Mr. Kelly's trial. The defense was blindsided. Okay, so they're quoting stuff that was in the opposition that they're now disputing, and they're talking about the whole thing about not having the 3500 material and other evidence, which they said that they turned over to Greenberg back in February. So then it goes on to say, let's see. I think these are all notes that they added on. So that pretty much ended their response to the defense. And what they have here, I'll read it to you guys since it's on here, but this is basically in the note sections. It says that Jane Doe number 2 would potentially be part of Mr. Kelly's trial. The defense was blindsided. Defense memo at page 4. Yet it is difficult to comprehend for what other purpose the government would provide 3,500 material for both John Doe number 1 and John Doe number 2. I said Jane Doe when I started this sentence. Other than to provide the defendant with statements, including their respective statements regarding the contact between the defendant and each of them, related to evidence that the government intended to elicit at trial. Notably, the evidence and statements produced to the defendant pursuant to Rule 16 from the inception of the government's prosecution, as well as initial statements produced pursuant to 18 United States Code 3500, all prior to the finalization of the juror questionnaire, included multiple allegations concerning same-sex contact between women and girls at the defendant's direction. The defendant, however, at no point requested that the potential jurors be questioned regarding their views on same-sex relationships or sexual activities. The defendant's assertions of severe prejudice is a basis to exclude the evidence related to John Doe number 1 and John Doe number 2. Therefore, rings hollow and appears to be a pretense aimed purely at excluding clear evidence of the charged racketeering activity, particularly where, as noted above, the potential jurors' views on this subject may readily be probed during jury selection. And they're actually responding there to the motion that Nicole Becker filed last week or over the weekend. And then it says, given that the nature of the allegation is similar to other allegations contained in the indictment, including that the defendant had contact with Jane Doe number 4 when she was 16, and in any event, while the evidence of the defendant's contact with Jane Doe number 1 may be prejudicial, it is not unfairly so. To the contrary, it is extremely probative of the reasons for which the defendant engaged in the alleged bribery scheme in the first place. Finally, the defendant's claim that he does not know the identities of Jane Doe number 7 to Jane Doe number 20 or John Doe number 1 and John Doe number 2 similarly falls flat. First, in its 3,500 material and Rule 16 disclosures, the government has provided the full identities of several of these individuals. Several, but not all. Come on now, people. And has provided sufficient detail about them that it is difficult to fathom that the defendant and his counsel do not readily know many of their identities. Even assuming that the defendant does not know most of their identities, an assumption the government finds difficult to credit, the government provided detailed descriptions of their allegations. But if he's saying that he doesn't know these people, then he's also saying that what they're saying is lying. So you giving detailed descriptions of the allegations means absolutely nothing. So anyway, detailed descriptions of their allegations against the defendant in its initial production of 3,500 material, given the defendant a more than sufficient opportunity to prepare its defense. Moreover, upon receiving the defendant's opposition motion, the government has now also provided a list of the identities to the defendant. Well, thank you very much for that. Notably, at no time did the defense ask for the identities. They had asked the government would have readily provided their names when the defense requested the identities of Jane Doe number 2 and Jane Doe number 3. Furthermore, the government did provide the name of Jane Doe number 1 and the names of lawyers representing many of the individuals discussed in the government's motion regarding other acts evidence in a letter to defense counsel dated February 5th, 2021, upon production of the initial 3500 material, further showing that at no time was the government intending to conceal their identities. For the reasons set forth above and in its initial memorandum, the government respectfully submits this motion should be granted. Child, the government is a mess, okay? Because they've already stated in a motion that Steve Greenberg got this information, but never, or he got the discovery. They didn't know what was in the discovery because it was given to Steve Greenberg. Steve Greenberg did not share it with the other counsel. And furthermore, he did not share it with the defendant. So seems like they should be able, Cannick should be able to step forward and say, hey, you gave it to an attorney who was ineffective and not doing his job. Now there are new attorneys on the job and we need the information. Plain and simple. So guys, that was the conclusion. That was the second part of their response, because if you remember, there were two motions that were filed. One was 55 pages, one was 61 pages. And so this video is in response to one of those. And then the video that I did previously is the response to the other motion. So what do you think? I mean, this is kind of becoming redundant. You know, I don't know. I can say it enough. The back and forth is getting ridiculous. So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.